everyone. Welcome. Welcome back to Do Different Better, where we talk about wealth, wisdom, and money moves, making finance simple for everyday people. I'm your host, Elaine Rasmussen, founder and CEO of Social Impact Now, Connective Institute, and general partner for the Integrated Capital Fund. Thank you for joining me today. In our last episode, we talked about the multi-trillion-dollar transfer of wealth for women, or to women, and why it's important now more than ever for women to learn about and start investing. Today, I'm going to be talking about how the rich and famous use and sometimes don't use estate planning, not just for after they're gone, but actually today. And we're going to teach you a couple of money moves to get you started. So I'll be talking about wills, I'll be talking about trust, and I'll be talking about my latest obsession, which is Swedish death cleaning. So let's get into it. In this segment, we're diving into the topic that can really transform how you think about your financial future, and that is the power of trust. Trusts are a financial instrument or an estate planning instrument to help you manage all of your property and assets. We're going to explore what trusts are, why the wealthy prefer trusts, and the different types of trusts that you can set up. Plus, I've got some juicy stories from famous people to illustrate the good, the bad, and the fabulous. But one thing, before we get started, here's a fun fact. COVID-19 really accelerated estate planning activity. And did you know that only 33% of US adults have created an estate plan or any of these documents according to LegalZoom? Here are some key demographics on who is and who are not making wills. Here's a data point. 27% of 25 to 50-year-olds have a will. That's like less than 30% of the American population, which means a lot of people are losing access to their assets, at least their families and their loved ones, because they don't have a will. 29% of Black people have a will or an estate planning document, which is a 12% increase over 2020 and has surpassed Hispanic Americans in estate planning since 2021. But this is most likely because Black people were disproportionately impacted by COVID death. So I think the point landed of how important estate planning was or is, because the process, which I'll talk about later, can be really, really painful if you don't have your estate planning in order. So why do so many people avoid estate planning? Well, I think it's kind of simple. Thinking about death is really uncomfortable. We don't like talking about it. We don't like thinking about it. Ironically, though, we love a good horror movie where a lot of people die. I don't know about you, but I'm a huge John Wick fan. And so just based on that alone, you would think that we would be much more open to talking about death. But there are lots of fears and lots of taboos around talking about death, especially thinking about planning for death, and in specifically in communities of color. It's really, really can be an uncomfortable topic. Here's some more data. 40% of American adults say that they don't have a will because they just haven't gotten around to it. Well, there's no time like the present. 33% of Americans say that they don't have a will because they don't have any assets to leave to anyone. And I'm going to ask you through our conversation today to rethink that, if that's something that you've said to yourself, either in the quiet of your own brain or out loud. But really, estate planning is taking control and providing peace of mind for yourself and for your family. It is a gift of love that ensures that your wishes are followed and your loved ones aren't left in the chaos. So let's make sure that we get you the information you need to make all your end-of-life wishes and your loved ones' wishes make sure that they're taken care of. So here's one concept that I want you to continue to think about through this conversation, and that's the concept of Swedish death cleaning. I said in the intro, I'm obsessed with Swedish death cleaning. Amy Poehler has a great show called Swedish Death Cleaning with real Swedish death cleaners. Swedish death cleaning is really about this notion of decluttering your life to make it easier for your loved ones after you've gone. Think of estate planning as part of that process, cleaning up your financial and legal affairs so that everything's in order and there's nothing for your children or your partner or other folks to have to worry about or think about as they really mourn your loss. But it is the kindest thing that you can actually do for your loved ones. And I'm obsessed. I'm just so obsessed. But now let's get into the thick of our discussion. First, we're going to talk about trust. So, what exactly is a trust? A trust is a legal arrangement where one party, known as the trustee, holds and manages the assets for the benefit of another party who is the beneficiary. Trusts are essential tools in estate planning because they really offer a good amount of control over how your assets are distributed compared to a simple will. The wealthy love trusts because they really provide a level of flexibility and protection that other tools just can't match. Trust can help you manage your assets during your life and ensure your wealth is passed down according to your wishes after you've gone. Trust can also help avoid the messy and often public process of probate. When you go through the probate system, and I'll talk about that in a little bit, everything is on public record. Everything, every part of the process is public. But before we can talk about trust, let's talk a little bit about probate. I think it's a very important concept to review so you can really appreciate the discussion on trusts and wills. So what is probate? Probate is a legal process of settling your estate in court after you die. Your property is gathered and inventory, your debts are paid, whether it's your house or taxes, but that anything that's left over is divided among your heirs. And usually the person who's managing the probate process representing the court is going to make that decision. So let's say that that first cousin, they might, if they're one of your living heirs, they might get an equal share. And maybe you don't like that cousin and you haven't talked to that cousin in decades. They might get a piece of your estate because you didn't have any estate planning documents outlining what your wishes were. So your personal representative is responsible for probating your will. If you have no will or you did not name a personal representative, the court is going to do that for you. Very much like an attorney is appointed to you. All the Miranda rights when you hear in the Law and Order episodes, the court will do this as well if you do not have somebody named as somebody who is responsible for managing your estate. Probating a will begins by filling in an application with the probate court. It is a special court in your state judicial system. Probate ends when all the debts and all the taxes of all of your assets have been paid and the assets that are left over have been distributed. If there is no disagreement over your will, a probate judge will resolve if there is disagreement over your will, a probate judge will resolve those differences. So once again, if you had some certain feelings about your children, your grandchildren, that will be all taken out of control by the judge who makes these decisions. And here's the other thing to know about the probate process. It can take a long time. A friend of mine just recently navigated the probate process with her mom, who unexpectedly passed. Her mom did not have a will. The process took over 18 months and was in another state. Her mom passed away in a different state than where my friend lived. So my friend had to bear the expense of traveling back and forth between Minnesota and Texas. So once again, when we talk about the burden we place on our loved ones when we don't have our wishes explicitly outlined through our estate planning documents, you could be having them incur thousands of dollars of expenses. And if they're not in a position financially to be able to support being able to manage and navigate that process, you're going to turn something bad maybe into worse, right? There may be fees or other costs that may be covered as part of the probate process. In these instances, it's common for these fees to be deducted from the estate payout, which I imagine is also not something maybe you wanted to do just because somebody has to travel back and forth. That means that's less money that they're going to have for them to enjoy, which is, I believe, probably the point that you wanted to make, is to offer them something for them to enjoy. You may need to hire an attorney to help you navigate this process or represent you, depending on how large or how complicated your the estate is. We'll review the entire probate process in another episode, but for now, I wanted you to get this information about the probate process so that you can kind of understand as we talk about wills and as we talk about trust, what does that mean and what does that look like? So now let's get back to trust. So what kind of assets go into a trust? Well, these are sort of your big ticket items that don't really have any fluctuations in ownership or value. So this could be real estate, financial accounts, life insurance, any mineral rights. Does anybody have mineral rights anymore? Collectible vehicles, sole proprietorships, partnerships, if you have stocks or bonds, if you have any holdings within corporations, if you have a non-retirement broker fund or mutual fund account, money markets, cash, checking and savings accounts, and annuities, CDs, safe deposit boxes, or any of your business interests. These are all things that can be held in a trust. So what does not go into a trust? That is retirement accounts like a 401k, a 403b. Certain kinds of annuities cannot be transferred into a living trust, meaning you're still alive while the trust is open. It is possible to name the trust as a primary or secondary beneficiary. So if you're working in a job, you have no anticipations of retiring from that job. When you sign the paperwork for 401k, they ask you who the beneficiary is. And you can put multiple beneficiaries. But if you are putting everything in a trust, you can name the trust as a beneficiary and the money will go straight into the trust. And according to whatever rules and guidelines you've outlined in the trust, that's how the funds will be disseminated. Another thing that can't go into a trust are HSAs, our medical savings account, or health savings accounts. These, since these accounts already allow you to use money tax-free for allowable medical purposes, they cannot be transferred into a living trust. However, you can name the trust as a primary or secondary beneficiary, very similar to your retirement accounts. And then finally, any active financial accounts. So any accounts you're using to pay your monthly bills, like if you have a checking account that you're paying your bills out of, or a savings account where there are withdrawals that are taken out on a regular basis, maybe it's to repay a loan to a family member, or it's paying down some sort of court-ordered judgment, then that cannot be put into a trust. Sometimes clients are concerned about keeping a working bank account separate from the trust because of the lengthy probate process. But it's because the amount that's usually kept in the account may not be as large, and there are beneficiaries that are outlined in your bank account, that may not be such a big thing to worry about. They ask you for beneficiary information, and what banks do is they have what's called accounts that are payable on death. And typically your checking account, because of the usability or the utilization of that kind of financial instrument, they will just automatically pay out once they receive certification of a death. So now let's talk about what are the different kinds of trusts. So, and we'll first start with revocable trusts. Or revocable. People will pronounce it different ways. Revocable, depends, I think, what part of the country you come from, but they mean the same thing. These trusts can be altered or revoked by the grantor at any time during their life. They offer flexibility and control, which is why they're a popular choice. For example, the late Aretha Franklin initially had a revocable trust, giving really a lot of flexibility to manage her assets as her situation changed. However, she didn't update it frequently, and that led to a lot of confusion after she passed. And I think there was a lot of infighting amongst her family members regarding her trust. An irrevocable trust, once it's set up, these trusts cannot be changed or revoked. They are often used to protect assets from the estate taxes and creditors. For instance, Michael Jackson's estate benefited from an irrevocable trust, which helped shield his assets and creditors and ensured his children's financial security. And then finally, specialty trusts. So these include charitable trusts, spendthrift trusts, and more. These kinds of charitable trusts allow you to donate to your favorite causes while getting tax benefits. Spendthrift trusts have spending directives and protect your beneficiaries who are receiving your assets. So it might help those you feel may not be the best with managing money. And you can set up some certain caveats within a spendthrift trust, say that 3 times, that says things like, I'm going to provide this person a monthly allowance or an annual allowance. So, fun fact, when Prince passed away without a will or trust, it led to a lengthy legal battle over his estate. If he had set up a trust, he could have protected his assets and ensured that his wealth was distributed the way that he wanted to, rather than being tied up in court. So we're going to wrap up this segment talking about trust and Swedish death cleaning. And I'm your host, Elaine Rasmussen. You've been listening to Do Different Better. Coming up next, we're going to talk a little bit more about trust, and then we're going to get into wills as well. See you in the next segment. Welcome back to Do Different Better. I'm your host, Elaine Rasmussen. We've been talking about estate planning, estate probate, and the power of trust. Now I'm going to talk about the essential topic of wills. But first, we're going to wrap up the conversation on the benefits of trust, and then we'll explore what wills are, the key components of a will, and common mistakes to avoid. Plus, we're going to spice things up with some juicy examples. So let's get into it. So, the benefits of trust. The reason why a trust is so an amazing tool to use as part of your estate planning is that, one, quite frankly, avoid probate and maintaining your privacy. Remember when I said probate is a very public, it's all public knowledge. It's all on public record because you're going through the court. But having a trust allows your assets to bypass the probate process. Which also, as we talked about, can be really time consuming. By using a trust, you can keep your financial affairs private. Like for an example, when Whitney Houston had her trust in place for her daughter, Bobby Christina, this helped them maintain privacy and control over how much assets there were, how the assets were going to be distributed. That whole conversation got to stay within the family as opposed to being out on public record. I am sure you've heard when somebody's filed for divorce, it's all over the TV. It's because you've had to file a public record saying that you're requesting a dissolution of your marriage, and all the paparazzi are coming. Now, you may not have paparazzi following you, but nevertheless, I don't think you want your private information public. Another reason for having a trust is a trust can protect your beneficiaries from creditors and their own poor financial decisions, right? So for instance, a spendthrift trust can ensure that your loved ones receive financial support without having access to large sum of money because, if you're concerned that they might use it or they might be taken advantage of, particularly if maybe they're a vulnerable adult or maybe they're just irresponsible. But you want to make sure that they're taken care of. So by being able to put in caveats on how much money is given to them at what periods or intervals of time, or it is common for parents to say that their children will get their inheritance at a certain age. I've heard as young as 18. I've heard as old as 50. The parents really want the person to make their own way in life and then have this financial inheritance at a later time in life as opposed to an earlier time in life. Some people will choose, we're going to give this inheritance to the person when they're 18 so they can support themselves through college or their young adult endeavors. So here's a fun fact to wrap up this conversation. Trusts have actually been used for centuries by the wealthy to manage and protect their assets, but they're not just for people who are super wealthy. Anyone can set up a trust to ensure that their assets are managed according to their wishes. So, what's the key takeaway? Trusts are powerful tools that you can use to avoid probate. You can protect your beneficiaries and preserve your wealth. If you haven't considered setting up a trust, now is a great time to start. Consult with an estate planning attorney, not a corporate attorney, not a criminal attorney. You really need somebody who this is what they do because they are going to be familiar with all the legal ins and outs and constraints and limitations that you need to know about all of your various assets and how to put them in or not put them into the trust. but an estate attorney can help you explore your options and find the best type of trust that's going to fit your needs. So now we're going to move on to wills. You may have heard about a will, but what exactly is a will? A will is a legal document that outlines how you want your assets to be spent and distributed after you pass away. It's a fundamental tool in estate planning because it ensures that your wishes are followed and helps prevent disputes among your heirs. I remember when I was dating my husband, he had been married before. I had not been married before. And when I first started dating my husband, he was like, I never want to get married again. I'm not want to get married again. And as somebody who had been in a relationship, a long-term relationship with somebody who I was not married to, and I didn't have any legal rights to any of our assets that we grew together because our assets were held separately. It became, there at time was a contentious relationship with me and his children. And so when I stepped into this relationship, I was very clear with my partner at the time of like, I do not want to fight with your children after you pass away. So it's very important to me that we have some estate planning or legal documents outlining our relationship and outlining what to do with our assets, because I will not fight with your children. That is not, and my husband was like, oh, well, no, like my children wouldn't do that. You never know what people are going to do in the midst of grief. Things change when someone passes away. So just to prevent anything from happening, you can hope for the best, but plan for the worst, right? So one of the key players in the process of a will is the executor. The executor is the person you appoint to carry out the wishes that are stated in your will. They are responsible for managing the estate. They are responsible for paying off any debts, and they ensure that your assets are distributed to your beneficiaries. Now, I had the uncomfortable conversation with my partner of my son is my executor. And the reason for that is my partner is a very sensitive person. And I know that if I were to pass away, that he would be a mess. And so I know that my son would also be a mess, but he is also the type of person of like, okay, if there's business to do, we can get through this. I can take care of this. And so I know that he will make sure that, and we'll just be in a really good state of mind to be able to execute what I need to be executed once I pass away. So that person can be anybody. It can be a friend, it can be a relative, it can be a lawyer, but you definitely want it to be somebody who's trustworthy and organized. This person that you're designating as your executor is pretty much going to be the CEO of your estate, and they are going to be responsible for handling everything that comes with that role. So make sure it's somebody. I always think it's good to have somebody who's a type A personality, somebody who is likes to dot the I's and cross the T's. They like to follow rules. Those are really good qualities in somebody who is an executor. Also, somebody who may not. I've heard that people choose their executor based on, I want somebody who doesn't have an emotional attachment to me. So that's one. You don't have to, but that is one way that one option you can use when you're deciding who your executor might be. So now let's break down the key components of a will. Appointing an executor. So as I mentioned before, the executor has a really, really important role. So choosing somebody who you trust is paramount. This could be a family member, a friend, or even somebody you don't know. You just pay like a professional, like an attorney or maybe your accountant. Designated, you want to, the next thing, so you have your executor, but then you have to designate beneficiaries for your assets. So this is where you explicitly outline who gets what, whether it's your home, your car, your jewelry, your sentimental items, your heirlooms. Clearly outline who should receive each asset. For example, Prince was, because he did not leave a will, this led to a prolonged battle over his estate, creating confusion around his musical publishing rights and what he owned and how that can be used. There was arguments about his estate and his other properties that he held, he had conversations with people about what he wanted to do, but none of that was written down. And people were saying that they had received conflicting information, which I don't even know to this day if all of his estate is completely settled. So you just don't want that to happen, whether you're a multimillionaire or you're a working class person. You just don't want to have any of your family go through that, right? But even outlining, one of the things about Swedish death cleaning is you actually give some of these sentimental items to the person before you pass away. That's even better, right? That's one less thing that has to go into the will. But the other thing that you must do is naming guardians for your minor children. If you have young children, this is perhaps the most critical part of your will. Designate who you want to take guardianship of your children should anything happen to you. You know, they're called accidents for a reason. They're not called on purpose. So unfortunately, many people pass away and leave orphan children. And so to know that if it's somebody particularly other than a living spouse, you want that designated, and God forbid that both of you pass away, because it does happen. And so outlining what you and your partner have agreed to as to what's going to happen with your minor children is really important. But it ensures that the people you want to care for your children are actually the ones who are designated to care for your children. And it also goes for pets. Right. So if you've got a pet child and you want to make sure that they're loved and cared for after you pass, you can include that in your will. So here are some common mistakes that you want to avoid, excuse me, when you are doing your will. So one of the things that people don't do is they don't update their will regularly to reflect how their life has changes. So life is full of changes, marriages, divorce, births, deaths. It's important to make sure that your will update these changes. For instance, if you got divorced and you don't update your will, your ex-spouse might be entitled to your assets. And that you might have a great relationship with your spouse, but you still may not want that. You might want all of your assets to go to your children, go to your nephew, go to your favorite niece, and that will take your assets away from them if that's not designated. You want to make sure that your will is legally valid and witnessed. A will isn't worth much if it's not legally valid. That means it's signed, but there is a witness that signs, and it meets the legal requirements of your state. Otherwise, it could be contested and potentially made invalid. The last thing you want to do, or the biggest mistake or common mistake that people don't do, is they don't communicate their wishes to their family to prevent any disputes that happen. Clear communication is key. It doesn't have to be this doom and gloom thing. That's another reason why I love Swedish death cleaning. It's all about making it a celebration. Have everybody over for a dinner and tell them what your plans are. Tell them what you like to do. If you think it's going to be contentious, maybe having a party is not the way to do it. Maybe you have that conversation one-on-one with people, but it is important to have a conversation. Who gets that sports car you've been restoring for the last 10 years? Who gets that heirloom painting of your great grandparents, right? Making it clear and asking people, what do they want? Sometimes what you think people want, they actually don't want, which is another part of what I love about Swedish death cleaning. It's inviting people into the process of, what heirlooms would you like? What of my things do you want to cherish? Is there something you'd like to have? And giving it to them before you die, right? It's a beautiful thing. I think it's amazing. And here's a juicy example. So when James Brown passed away, he left behind a will, but it was contested by his family members, leading to a very prolonged legal battle. There was, having clear communication and having a updated certified will could have avoided a very messy and very public situation. So here is my call to action for you. I want to challenge you to start today. If you can't start today because the day is already gone, put some time on the calendar to just start drafting a will. I remember I had a conversation with my partner and I was saying, hey, we've got to get our wills in order. I have a will. My partner didn't have a will. I'm like, let's, it's time to update. We are in a relationship. Let's update our will. You create a will. I will update my will. And let's make sure that we're on the same page. And we started talking about what we wanted to do with our assets. And it became clear we had different visions of what to do. So it just helps. It's not a destination, it's a journey to be able to start having that conversation with your partner, your loved one, your siblings about what's important to you, what's valuable to you, what do you see, what kinds of situations might you be in. Of course, you're not going to be able to know and dream up all of the situations, but the whole idea is that you're starting the process. And I just want you to start writing things down. Maybe it's in your journal, maybe it's in a notebook, but just start thinking about, okay, what would I want to give away? What do I have of value? And you do have things of value, right? I don't care who you are. I don't care what job you have. I don't care what you do in life. You have something that's valuable and important to you that you want to make sure has a home after you pass. So putting the things in place to ensure that that happens is the greatest gift that you can do. So that's it for this segment on the power of wills. By taking these steps, you can ensure that your legacy is protected and your loved ones are cared for. Thanks for tuning in to Do Different Better. In the closing segment, I am going to talk about other estate planning tools like power of attorneys and healthcare directives, gifting and tax strategies that are used by the rich and famous. Come back and see me in the next segment. Hey there, listeners. Welcome back to the Do Different Better Show. I'm your host, Elaine Rasmussen. If you're just joining us, we're continuing our deep dive into estate planning. But this time, we're talking about the essential tools you need beyond a trust or a will. We're going to cover power of attorney, healthcare directives, and some savvy gifting and tax strategies. Plus, we've got some stories from some famous celebrities to illustrate the good, the bad, and the fabulous. So let's get into it. When we think about estate planning, trusts and wills are typically the things that you first come to mind. But there are some other tools that you can use to ensure that your wishes are honored and your loved ones are taken care of. Excuse me. These are tools such as power of attorney, healthcare directives, and various gifting and tax strategies. So let's talk about power of attorney and healthcare directives. So my son is a military vet. He was in the Army for 7 years. As part of his time during the Army, he was overseas and he was in a combat zone. But before he left, and I think at the time he was 24, we created a power of attorney. And the power of attorney was I was given his power of attorney over all of his affairs. And that we did that for a few different reasons. One, we did that. He was going to be overseas and probably we knew that he would eventually be in a combat zone, which meant there's no internet in a combat zone. there are no phones in a combat zone, or not accessible phones in a combat zone. And so if there was something that came up with his bank or his home, or he has a duplex, if there's something that came up with any of his affairs, that I could intercede and make decisions, or at least be in communication with him and execute anything that he needed executed. If he needed his overdraft in his bank account taken care of, I would be able to communicate with the bank and do that. The power of attorney allowed me to do that in his absence. So the power of attorney isn't just for when somebody dies, right? There are lots of reasons to have a power of attorney. If you ever become incapacitated, you go into a coma, you have amnesia. I don't know. Do people still get amnesia? I don't know. But having a power of attorney is just a good thing, because you never know when you may be inaccessible and somebody might need to do something on your behalf. A partner, a child, a sibling. It's just good to have somebody who has power of attorney. You can have what's called limited power attorney. So you can say, I'm giving this person a power of attorney for a limited amount of time, for a limited number of assets. So for example, my son may have wanted to say, okay, mom, you're going to have power of attorney only over my bank accounts and only while I'm overseas, right? But what we did was we made it a permanent power of attorney, because he can always come back and change and update his power of attorney when he came home. So, and we've actually done that since he's returned home from it being overseas. So having a durable power of attorney is really great for financial decisions. This is a document that gives someone your trust and authority to handle your financial affairs in case you are unable to do so. This can be crucial in situations where you are incapacitated. For example, if you had a car accident and you are unable to manage your finances, maybe you broke your hands and you can't sign anything, having a power of attorney allows somebody else to sign for you, because you clearly don't have the capacity to sign your name. But This person can be designated to pay your bills, manage your investments, and keep your financial life running smoothly without any hiccups. And here's one example. Richard Pryor, he had a power of attorney in place. If you're not familiar with Richard Pryor, he's a famous comedian who was diagnosed with multiple sclerosis. I had the wonderful opportunity of meeting him later in his life, and he's just a gem of a human being. But as his health declined as a result of his multiple sclerosis, he had trusted advisors who managed his affairs while his health declined. And having that power of attorney, that durable power of attorney, helped ensure that his financial matters were taken care of, like getting his medical bills paid, making sure his wife was taken care of, and making sure his children were taken care of. A healthcare directive and living wills. These are also really great tools. These documents outline your medical preferences if you're unable to communicate them yourself. A living will specifies what types of medical treatment you do or you don't want. A healthcare directive appoints someone to make medical decisions on your behalf. It was really interesting when me and my partner were talking about our healthcare directives, and he was very pensive, I'll say that, about trying to anticipate all of the possible things that could happen with all the possible things that could happen as a result of being incapacitated, like coma, amputation, and do not resuscitate orders, and when should you not resuscitate, and being in a vegetative state, and how long if you're in a vegetative. And he was just getting so wrapped around the axle. And he's like, well, I don't know what I would want. I'm like, no one knows what they would want. You're just going to have to make some good guesses. Let's see if Mr. Skittles joins us on our show today. He just jumped up on the table. But no one knows. You're just going to have to make some guesses. But here's the great thing. You can always change your mind. As long as you have the capacity, you can change your mind. So you may want do not resuscitate order. And in a year from now, you might, no, I want extraordinary measures to be taken to keep me alive. Well, you can change your health directive. So it's not very difficult. You complete the form all over again. And once again, you sign it, you have it witnessed, and it's all good, right? So now let's move on to actually gifting and tax strategies, right? So there are some gifting and tax strategies that are used by the rich and famous that many people don't know about. Some accountants don't know about these things, right? So you can ask your accountant, ask other accountants to talk about what are some of the benefits of gifting and other kinds of tax strategies that can help you keep as much of your assets to your family or in your trust as possible. So let's talk more specifically. Using annual gift exclusions. So once again, I am not a tax accountant. I am not a CPA. I'm not a tax professional. Go see professional advice. But here's what I will share with you. The IRS allows you to give a certain amount of money each year to as many people as you want without paying gift taxes. As of 2023, this amount was $17,000 per recipient. This is a great way to transfer wealth tax-free while you're still alive, right? So once again, as of 2023, you could give as many people as you like $17,000, and that is not a non-taxable event for them. So when we think about setting up our philanthropy and wanting to give individuals philanthropy, maybe they're not your family, you're like somebody who did something really great for you, and you want to gift them something, but you're worried about the tax implications. And so this is something that is a great tool that you could leverage and use. One example is Oprah Winfrey. She's used her wealth to gift generously to her family, friends, and charitable causes. And by using these gift exclusions, she can share her wealth without incurring heavy taxes. Another one you may be more familiar with, especially if you have children, is setting up a 529 plan for education purposes. So a 529 plan is our tax advantage savings plans that are designed to help you pay for education. Last time I looked at 529 plans, they could be used for education for yourself or for a child, but they can be a fantastic way to ensure your loved ones are financially prepared for college expenses. And I'm not sure, you might want to check this out. You might be able to also use it for like trade school. I don't know if you heard, but there's an electrician shortage. We need more electricians. And so we really need folks going to the trade schools. So check your 529 plan and see if trade schools are included or other kinds of private certification programs are included as part of where you can use that 529. And 529 plans are money you put in, and it is money that usually you can pay pre-tax. And so you're not paying taxes. It's reduced from your income, or it's post-tax. So if you withdraw it, you don't have to pay taxes on it. So look at your 529 plan, see how it's set up. If you're interested in a 529 plan, there are lots of institutions, financial institutions that are offering them. You can find out more details about what are the parameters of their 529 plans. Shaquille O'Neal has been very open about setting up educational funds for his children. This ensures that the resources that they need for their education are is reinforcing his value that he places on learning. Now, mind you, Shaq, I think his kids are going to be fine no matter what, but it's a lesson that this is something that's important. And I love the fact that he is very public and talks about this. Here's another opportunity that you can leverage, and that is charitable giving, or what's called a donor advised fund. So donor advised funds, charitable giving is not only to support causes that you care about, but can also provide significant tax benefits while you're alive. Donor advised funds allow you to make a charitable contribution, but receive an immediate tax deduction and then recommend grants over time. Typically, donor advised funds are held at either a financial institution or a charitable organization, such as a community foundation. So if you have an investment account, let's say with Charles Schwab or TD Waterhouse or TIAA-CREF, typically these financial organizations also offer donor advised. You can use their instrument called donor advised fund and set up your own donor advised fund. And in that donor advised fund, you're going to tell them, these are the things that I want my money to go to, while getting your tax benefit. The money doesn't go to you. It doesn't go to your heirs. It goes to charitable causes, which typically means a nonprofit or a 501c3. So if you're a big fan of the Humane Society, you can set up a donor advised fund where when you, depending on the amount of money you put in, that money will be given out to the charity of your choice at a certain point in time, but you get the tax benefit today. So once again, talk to your tax professional. They can talk more about that and talk about your particular situation of how you might want to leverage donor advised funds. So one great, famous celebrity that practices donor advised funds, and that is John Legend and Chrissy Teigen. They've set up charitable foundations and donor advised funds to support a variety of causes that they're passionate about, all while benefiting from tax deductions. This is another way that wealthy people actually hold on to their money. They're reducing their tax liability by giving money away, right? So what's great about, once again, donor advised funds or setting up your own charitable foundation, maybe you set up your own foundation, and I highly recommend, if that is something you're interested in, you work with a lawyer to help you set that up so you set it up correctly. But a foundation, a family foundation, sometimes you may hear, so-and-so Johnson Family Foundation. These are foundations that were set up by the family, and usually there's typically a very clear outline of, these are the things that we support. It could be early education learning, it could be economic development within a certain community. There is like the J.N. Rose Fellows Foundation, which is located on the north side of Minneapolis. They are a family foundation that is hyper focused on funding projects and initiatives in North Minneapolis. But as the creator of the foundation in your name, you actually get to use that foundation. You get to make the directives for whatever it is, the giving that how you want it to be spent, the kinds of initiatives you want it to be spent on, as long as that is, you are not personally benefiting, right? So, but once again, talk to a professional, talk to your community foundation if you're interested in your donor advised fund being held at your local community foundation, or you can talk to an investment advisor and they can tell you more about if their organization that they work for provides donor advised funds. But many of the larger financial institutions and even some of the smaller ones offer that. So Here's my call to action to you. Consider implementing these estate planning tools that we've talked about to enhance your plan. Start by consulting with an estate planning attorney to explore the options and find the best strategies for your situation. There are organizations and nonprofits that can actually help you do some of this for little or no cost. Don't let fears and taboos hold you back. Estate planning is about taking control and ensuring your fears, your wishes are honored. It's a powerful step towards doing different better together. That's it for today's show on estate planning tools. By taking these steps, you can ensure your legacy is protected and your loved ones are cared for. Thanks for tuning in today to the Do Different Better Show. I'm your host, Elaine Rasmussen. Until next time, let's all do different better together. Don't forget to subscribe. Leave a review. Tell me your questions, your thoughts. If there are people you want me to interview, please let me know. Share in the comments and share this episode with your friends. I can't tell you how important and invaluable it is. Let's make sure everyone is prepared to protect their wealth and secure their legacy. Bye for now.